interlocutory application for little modification, and that error has occasioned due to typical error, Lordship. So that may be listed tomorrow, Lordship.
All right, tomorrow.
And deeply applied.
Please, Your Lordship. Lordship, I beg to mention one matter for admission, my lord. Next week, Lordship.
Yes. Admission, what is the subject matter?
Subject matter is appointment of medical staff, Lordship, technical staff, Lordship.
Let it come after the vacations.
Lordship.
15th of July.
Lordship, in June and for June, Lordship, because
15th of July.
They are going to make the selection, Lordship.
When?
Sooner, Lordship.
Right, then 19th June.
My lord, this matter may be listed on Friday, my lord. Last posting was 18-2, my lord, for admission, my lord. Last posting was 18-2. So I sought posting on 5th June, my lord, Friday, my lord, for admission, my lord.
All right, 5th June.
May I please, Your Lordship? With the consent of the other side, I beg to mention item number 40, Your Lordship.
40.
40, Your Lordship.
Yes.
Lordship may adjourn the matter for the day, Your Lordship, as my senior Mrs. Egan is out of station.
Have you taken consent of the other side?
Yes, Your
My
Lordship.
lord, I for the petitioner, my lord, matters pertains to the pension matter, my lord.
Let it be listed on 17th June.
My lord. Deeply, Your Lordship.
As on the request made by the council for the on behalf of learned Ms. Ega and learned CGC.
Lordship.
Matter stands deferred to be listed on 17th of June. Yes.
I beg to mention on list on 5th of June, my lord. What is the urgency, my lord?
What is the urgency?
My lord, urgency is that you lordship pass an order to direction to the private respondent to implement the bank manager, my lord. Already implemented, my lord. So the selection already award, my lord, what is the urgency? You lordship already had your lordship.
Let it be on 8th. 8th of June.
May I please, Your Lordship?
Yes.
I beg to mention item number 9. I am for the petitioner. The conducting of the MS D. Chaudhary is suffering from back pain. So it may be adjourned.
Item 9 on the request made on behalf of MS D. Chaudhary, matter stands deferred to be listed after 2 weeks.
Much, my lord. With the consent of respondent, I beg to mention item number 41, my lord. Lordship, taken up the matter after 2 weeks.
41.
Yes, my lord. I'm for a petitioner, my lord.
You are for the petitioner.
Yes, my lord. The conducting council KP1 has some difficulty today, my lord.
Item 41 stands deferred to be listed again after in the month of July on a date to be fixed by the registry.
Lordship, with the consent of the respondents, I beg to mention item 48 on today's list.
48.
48. Lordship, I appear for the petitioners. Lordship, we are seeking 2 weeks' time to file our reply.
Item 48 on the request made by Mr. A. Athriya, matter stands deferred to be listed after 3 weeks.
Lordship, there's an interim that may be continued.
Interim order passed earlier.
Public.
May I please, the Lordship? I beg to mention item number 17, Lordship. Due to some personal difficulty of my senior Lordship, matter may be adjourned for a week.
Item
for
17,
the petitioner, Lordship.
Item 17 on the request.
Item 7.
17.
Yes, Lordship.
On you are mentioning on behalf of Mr. Dasgupta.
Lordship.
On the mention made by the council on behalf of Mr. A. Dasgupta and senior council, matter stands deferred to be listed after 2 weeks. Yes.
I was content matter, it is not listed for many days. From since 33, 26, 4 weeks already passed. It may be early listed.
On 10th of June. 10th June.
When?
10th. 10th of June.
10th of June.
Yes.
I am asked on 5th of June.
5th is not possible. 10th. Keep it on 10th.
10th June.
Yes.
May I please, Your Lordship? Lordship, I beg to mention for listing of 2 matters, Lordship, on 18th, Lordship. In both the matters, the petitioner is same, but the subject matter is different, Lordship.
You want the matters to be listed on?
18th of June.
Why?
Lordship,
What
this
is-
matter was last listed in 2024. Since then, it has not been listed, Lordship.
Then let it come after vacation. Let it be listed in the first week, in the week beginning from 13 July, on a date to be fixed by the registry.
Obliged, Lordship.
Please, Lordship, I am praying for withdrawal of a writ petition.
Tomorrow? Yes.
May I please, Your Lordship? I beg to mention the listing of two arbitration petition, Lordship. Similar subject matter for the appointment of arbitrator. We have filed the replies and everything. Any date, Lordship, after 10th of.
After 10th?
Yes, Lordship. Any date.
All right, 12th?
Yes, Lordship. Highly obliged, Lordship.
May it please, my lord. Prayer seeking listing of a admission matter, my lord. Any date, my lord? Next week. Matter part is promotion, my lord. That is
17th. June.
17th, my lord. I'm so
Yes.
obliged.
Please, Lordship, I want to mention regarding listing of two writ petition, Lordship, for admission, Lordship. Next week on any date, Lordship.
Next week. Let it be on 17th June.
Obliged, Lordship.
Item 1.
Please, Your Lordship.
Yes.
to rejection of the petitioner in the review.
Yes, yes.
May please, Your Lordship. The matter relates to rejection of the petitioner in the review medical examination conducted by the respondent's Lordship. Your Lordship will find the report at page 17.
No, this is after the review medical examination.
No, page 17 is the rejection of the candidate.
Page 17. 17 is RME.
Yes, he was declared unfit due to defective vision, 6/12 both eyes.
But you're relying on the prescription of the
Registrar of Ophthalmology of Fakultin Ali Ahmed Medical College, Borpeta. That Your Lordship will find at page 78. Your Lordship directed me to file an additional affidavit to bring it on record, and the same was done, Lordship, at page 78.
78. But this is after the RME.
Lordship,
78 is not with me, Lordship. Petition
Huh?
78.
Additional affidavit you have not been served.
no, additional affidavit. She is referring to writ petition, Lordship. I'm referring to the additional affidavit.
Additional affidavit.
So may I pray for passing of a similar order as Your Lordship passed in?
No, this is after. No, your medical opinion of the Borpeta hospital is after the RME.
After the rejection.
Then why should we disbelieve the RME and the DME?
I'm placing a judgment passed by Your Lordship in a similar fact situation wherein Your Lordship directed the petitioner to file a representation and the respondents to take note of the medical reports and conduct review medical examination.
That must have been before. That must have been before the
Yes.
RME was there, or during the RME. No.
Now, at page 3, para number 3
Hmm.
of that order, Your Lordship will find. In fact, in that particular case, Your Lordship, the petitioner was examined. The petitioner examined himself after the rejection of the RME and not based upon the reports prior to RME.
Yes, madam. What do you say?
Yes, I have to.
You go through it. Will call
Yes.
back. Call up.
In fact, she was the counsel appearing in that particular case.
All right. After some time.
Yes.
Item 2.
Yes.
My lords, it's a section 11 petition, my lords, where the LOA is at page 45. And the contract agreement starts at 50.
Counsel to the parties issue notice, returnable 4 weeks. Was there any date fixed in the earlier matters?
No, my lords. Although they are technically all between the same parties arising out of a series of contracts. 8 of
You
them.
mentioned the dates after the returnable date.
Yes, my lords.
Anyone for the railway?
My lord.
Mr. Gupta, Learned CGC enters appearances on behalf of respondents 1, 2, 3, and 4. Therefore, notices are waived. Extra copies be furnished within a period of 1 week from matter be listed after the returnable date.
Obliged.
Yes.
Please, your lordship. My lord, both item 3 and 4 are, my lord, arising out of the common order dated 11/6/2025, my lord. Both of these were candidates, my lord, who participated in the state level recruitment commission of class 3 posts. And they, upon not receiving information
Yes.
about
Okay, Mr.
Yes, ma'am.
Mr. Rai Borthakur appears for the petitioner. Issue notice returnable 4 weeks. Steps on the respondent by speed post within 1 week from today. They being dissatisfied with the order dated so and so, past and so and so. Both are common orders.
Common order.
All
Different rates, stacked matters, but common.
Yes. This is item number 3 and 4.
3 and
Same
4.
order.
Same order.
Yes.
Item 5.
Obliged.
Yes.
On the respondent supposed to file affidavit.
Who's for the respondent?
May I please, lordship?
Yes.
Here, Honorable Court last occasion directed to bring the SLC minutes on record by way of affidavit, lordship, and that affidavit is sent for vetting. Within the 2 days, we get filed affidavit.
Within 2
days, the affidavit will be filed, lordship.
Okay. MSS Borwa, Learned State Council. You are for the state now.
Yes, lordship.
State Council submits that the affidavit will be filed within the course of the week. So, considering the submissions made, release this matter again.
Your lordship, I'm appealing for PWD on behalf of P. Nayak, your lordship.
Yeah, are you filing any affidavits? Are you filing any affidavits?
As of now, no, lordship.
Matter stands deferred to be listed again in the week beginning from July 13th on a date to be fixed by the registry. The petitioner is also permitted to file rejoinder affidavit. Such an affidavit that may be filed with the state.
Highly obliged.
6.
Take your lordship, my lord. My lord, I am the inspector of taxes, my lord. The office of the commissioner of taxes, Gauhati, my lord. As because my lord, I was I have been suffering from various medical ailments. Therefore, submitted various representations before the authority concerned. And subsequently, my lord, I was transferred to Srirampur, Koprasar. I ordered that on deputation, my lord, on 28/5/2025, my lord. And since I could not join, my lord, I was then, after an order, I was suspended from service, my lord, and suspended on 28/8/2025, my lord. And after that, my lord, again, my lord, without due process, my lord, my suspension has been again extended, my lord, by order dated 21/2/2026, which is the last page that is on Annexure Z, page 77, the last page. I only want that now, my lord, the post has already been filled up, my lord, as per the instruction, my lord, and therefore I pray before lordship that my suspension order be revoked.
Mr. Gogoi, anything?
My lord, so far as the, my lord, prayer made in the writ petition is concerned, my lord, as per the rule under, my lord, rule 13 and 14, my lord, there is a specific provision for preferring appeal against the order of suspension under Rule 6. Lordship may
Alright.
kindly have a look at that part, my lord. Specifically, it says, my lord, that every government servant shall be entitled to appeal as hereinafter provided against an order passed by authority placing him under suspension under Rule 6. That is Rule 13. And 14 says appeals against order of suspension.
He is not aggrieved by the suspension order as such. He is aggrieved by the fact that you have to review the order.
My lord, order has been reviewed, my lord. In fact, my lord, so far as this last annexure is concerned, dated, my lord, 21 to 2026, whereby, my lord, it has been extended till 27/5/2026. Subsequent to that, my lord, another order has been passed on 23/5/2026, whereby it has been extended till 27/8/2026. I can place it, my lord, if
Yes, yes.
but that will have to be put to challenge, my lord, if at all my other side wants to challenge it. Because
Only my
there
lord,
is a subsequent development, my lord.
my lord, I want to join my lord. Now I will be,
That
but only
cannot be a ground.
and the post is Kiranpur, that is already filled up, my lord. Only because there are various medical documents I have annexed, lots of series, my lord, annexer.
Why don't you file an appeal?
The annexer app, annexer app, my lord. If you kindly lordship look into the annexer app, page 28.
Mr. Rahman,
my lord.
There is a provision for an appeal.
I have made a representation, my lord. I have made a representation before the authority concerned, which has not been considered, my lord. Mechanically, it has been extended, my lord.
Then we'll issue notice here, Mr. What counsel to parties issue because return.
My lord, I am SS A. Rahman, my lord.
4 weeks. Mr. D. Gogoi, additional AG for the state accepts and appears notice on behalf of all.
Yes,
all the respondents. Therefore, notices are waived. The extra copies be furnished within a period of 1 week from today. Mr. SSA Rahman appeals for the writ petition. Please, after the returnable date.
Obliged.
Yes.
Obliged. Highly obliged.
Item 7.
Obliged.
Wait, please, your lordship. My lord, in the IA, my lord, there is a typographical mistake, my lord. In respondent number 7 and 8 has been mentioned as a Maibong division instead of Ubrangshu division, my lord. I pray for correction of that.
IA number 2220 of 2026. Any objection, Mr. Nayak?
No, no.
But counsel to the parties, this IA has been filed seeking correction on respect of the proper address of respondent number 7 and 8 in WPC. Sorry, sir. IA number 1393. Respondent number 7 and 8 in WPC 2220 2026. So let the counsel for the petitioner submits that this error had occurred inadvertently. He seeks liberty by filing the IA to make the necessary corrections. Counsel for the respondents do not object to the prayer made. Accordingly, IA stands allowed. Disposed. The petitioner is permitted to make necessary corrections by reflecting the correct address of respondents 7 and 8 as is reflected in the prayer portion of the IA. Stop the writ petitioner applicant will file the amended post title within 10 days from today. I disposed in the writ petition, you write in view of the order passed today in IA number so and so. The petitioner is permitted to file the amended post title within 10 days. The registry will list the matter after the amended post title is filed. Mr. P. Nayak, additional AG for the response. Yes.
Item 8.
Yes, interstate transfer, is it possible?
Lordship, it is not possible, Lordship. My instructions have come. So it says that it is not possible. So
What do you say? How is interstate transfer possible?
Lordship, thing is that we have filed one representation before the department, Lordship. But kindly, direction will be given, Lordship, to consider the representation, Lordship.
that I can ask my clients to, Lordship, dispose it off. Perhaps the result would be the same.
All right, we'll dispose of the matter, directing them to dispose it off within a fixed period. We are not expressing anything on merit.
Lordship.
All right, counsel for the parties, this writ petition has been filed by the petitioner, praying for a direction to the respondents to consider his prayer for interstate transfer from Assam to the state of Rajasthan. Stop petitioner is presently serving as what is he serving as? Community health officer. Community health officer with the National Health Mission on contractual basis. Stop. In this context, the petitioner has preferred the representation. Where is the representation?
Lordship, Annex 3, Lordship, case 31.
The representation dated 26, which the petitioner claims is pending before the authorities concerned, and the same has not been disposed of. Stop being agreed, the present petition is filed. Stop. There are Mr. R.K.D. Chaudhary, learned DSGI, Senior Counsel, assisted by Ms. L. Devi, submits that on instructions that the petition can be closed with a direction to dispose of the representation, leaving the issue to be decided by the authorities as per the provision of law. Considering the submissions made, and considering the limited prayer of the writ petitioner, the writ petition stands disposed of, directing the respondent authorities, more particularly respondent number
2. That's what 2 and 3, Lordship.
2
and 3, Lordship.
3.
3 also, 3 is the state, Lordship.
Lordship, he has filed a representation to the minister and all. Your Lordship will just direct the respondent number 1, 1 and 2, Lordship.
No, but let it be decided by 1.
Lordship.
By respondent number 1 to examine the claims of the writ petitioner and pass appropriate orders disposing of the same within a period of 30 days from the date of receipt of a certified copy of this order. Stop. It is made clear that this court has not expressed any opinion on the merits of the claims made by the writ petitioner. Stop. Writ petition accordingly stands disposed.
Obliged, Lordship.
Obliged.
Item 10.
Made, please, Your Lordship. I'm agreed
Yes.
by the downgrading of my annual performance appraisal report, Your Lordship, for the year 2013-14 and 2014-15.
You have to issue notice. But
Yes.
Counsel for parties.
One delay is there, delay filing the representative, 2000, now it's 2026, appears 66.
You raise these objections in your counter evidence.
And jurisdiction point also may be kept open.
Of course, we are only issuing notice. You raise your objection. But counsel for parties issue notice, return among 4 weeks. Mr. S. A. Medi, learned CDC, appears and accepts notice on behalf of all the respondents. Therefore, this is a waive. Extra copies be furnished within a period of 1 week from the 5th. Mr. Devi, T. Devi, appears for the petition.
I'm very grateful, Your Lordship.
Item 11.
May I plead the lordship?
Yes.
My lord, the petitioner challenges his termination, my lord. At this stage, my lord, the notice may go, my lord. The petitioner preferred statutory appeal also, that has been also dismissed, my lord.
Right, Mr. B.P. Bora, Counsel Petitioner, Mr. P. Chakraborty, learned CGC for the respondents. Issue notice, returnable 4 weeks.
1 to 5, Lordship. Only, Lordship, one thing, Lordship. The jurisdiction part, territorial jurisdiction part, that may be kept open, Lordship.
Mr. B. Chakraborty waits for respondents 1, 2, 3, 4, and 5. Therefore, notices are waived. Extra copies will be furnished within a period of 1 week. Please steps on respondent 6 by speed post within 1 week from today. So, Mr. Chakraborty submits that the question of maintainability of the writ petition on the point of jurisdiction.
But that question has been already decided in earlier round of litigation.
That part has not been
page
decided.
151, my lord.
That
We
part
will,
has not been.
we will consider it at the,
Yes, my
on
lord.
the next
Yes, my
agenda.
Obliged, my lord.
Item 12.
My lord, there is one private respondent, my lord.
Yes, you take steps.
Yes, my lord. Obliged.
Right, my lordships. This matter relates to suspension, my lord, is second round of litigation. In earlier occasion, my lord, my writ petition was dismissed. On that, my lord, that is page 36, the relevant para 30, page 38, para 6 and 7, my lord.
Mr. Bora, get your instructions here.
Yes, my lord. I'll obtain it.
Mr. N. Hawk for the petitioner, Mr. V.P. Bora, learned counsel representing the Health and Family Welfare Department. The petitioner challenges the suspension made by the authorities and on the ground that the same has not been reviewed and no departmental proceedings have yet been initiated. Mr. Bora will obtain instructions in the matter. So, although notices are not issued, at this stage extra copies will be furnished within 3 working days. List this matter after 2 weeks.
Obliged, my lord.
13.
Yes.
May I please, your lordship? My lord, this petitioner, he is subjected to, my lord, 2 parallel proceedings. One is the criminal and one is the departmental proceeding, my lord. He was originally suspended for, my lord, demand of the bribe, my lord. Then he was placed on suspension for his detention of 48 hours, my lord. Thereafter, my lord, his suspension was withdrawn by the department. Thereafter, he's continued for a service. Later on, again, my lord, recently again he has placed on suspension on 8/5, only on the basis of that the criminal case is pending, my lord. My lord, the departmental inquiry which has been conducted absolutely shows that it is absolutely based on the material which has been collected during the investigation, and the officer who conducted the departmental inquiry, his inquiry report absolutely shows that it is nothing but only relied on the statement of the IO, my lord, who conducted the investigation, my lord. So there is a chance of causing prejudice to my case, my lord. So I pray, my lord, the similar order also I relied on, which has been lordship has pleased to pass in a similar order, page 71, my lord, in a similar situation, my lord.
Now, what is the stage of the criminal proceedings?
Same, my lord, the criminal, the evidence now, my lord. Inquiry.
Evidence.
Yes.
Right. And the departmental proceedings, they have issued show cause.
Second show cause reply we have submitted, my lord.
The
inquiry 24, my lord, thereafter nothing. In 2024.
Inquiry officers appointed.
Yes. Appointed, he has given an inquiry report only based on the IO's evidence, my lord. Nothing.
He has submitted the report.
Yes. Only basis of the IO's. We have replied thereafter nothing.
No. Is the inquiry pending or is it concluded?
Yes. Pending. Only pending.
But you mentioned something about submission of a report. by the.
That is the enquiry report by the initial enquiry report, my lord. Thereafter, the show cause has been issued to us, my lord. Second show cause.
Yeah, Mr. Gugoi,
Lordship. Take the instruction, Lordship. For different things.
I heard Mr. A. Bora, learned senior counsel, assisted by Mr. J. Kwari. For the petitioner, Mr. R. R. Gugoi, learned standing counsel excise, appears on behalf of the respondents. Petitioner is aggrieved by the proceedings initiated against the petitioner by show cause. Where is the show cause?
Show cause, my lord, second show cause. First show cause at, my lord, page 50.
No, you are before this court now in respect of the second show cause.
First show cause, my lord. Initiation of the DP, my lord.
Page number 15.
50, my lord. 50.
50. Yes. This is in 23.
This is in 23, my lord. Then the second show cause your lordship will find. Page 57. And the impugned enquiry report, my lord, page 58.
No, the inquiry is over. This is the inquiry report submitted. Page 57.
Yes. Thereafter, my lord, I have been show cause. Now the.
No, you are being show cause prior to.
Yes. Once we have been show cause initially, putting me on suspension.
Right.
Before the initiation of the inquiry, my lord.
Correct.
Yes. Thereafter.
No. This show cause at page number 50.
This is page 50. That is the first show cause, my lord. Without inquiry being completed, my lord.
No, the inquiry begins after the show cause.
Yes.
Inquiry, the
be initiated, my lord. Thereafter, nothing.
No, thereafter, you file your reply. And then finally, there is some report submitted.
Yes.
Are you challenging this?
Yes. We have challenged that also. Yes. Everything we challenge.
57 seconds.
misplaced 57 আমার নিমিলে ইয়ার 57 এর পিছে সেকেন্ড শো করে নোটিস আর 57 এর না এটা কি হবে এখন কি নিয়ে শো করলো সেকেন্ড শো করে 19
This 57 is the show cause before imposition of punishment on the basis of the inquiry report. Now
we have challenged that also, my lord. That inquiry report, because that will cause prejudice, because if lordship knows that judgment, if the inquiry report shows prima facie that there is no material on the basis of which the inquiry been conducted, because the material conducted is the IO's statement only, the inquiry report suggested, and which is the subject matter of the criminal trial.
The inquiry proceeds with the show cause.
Yes.
It culminates with the order of the disciplinary authority. As on date, there is no order passed by the disciplinary authority.
Yes.
Rather, a notice is issued asking you to represent. So the disciplinary authority is yet to pass an order.
Yes.
Once an order is passed, then there is a question of whether you are prejudiced or not.
Well, then it will attain the finality, maybe, my lord. That's why we have challenged the, my lord.
At this stage,
Lordship, kindly see the order of the lordship. The page 71.
That is at a stage.
The similar circumstances, my lord, absolutely similar. Because of that judgment of the Supreme Court, it says that if there is a chance of prejudice, my lord, then paragraph 3, my lord.
Yes.
The learned stream counsel's petition submit that the pursuant to the investigation pursuant to the FIR laws, the charge sheet was filed and the matter is presently under trial. Meanwhile, the department pursuant to the so-called notice proceeded with the departmental inquiry. The inquiry officer concluded the inquiry. Here also, my lord, he has concluded, and the inquiry report was submitted before the disciplinary authority. That apart, the suspension of the petitioner has also not been reviewed as a required under the law as well as the office memorandum dated so-and-so. The learned counsel so-and-so, relying on the judgment of the apex court in Paul Anthony versus so-and-so, reported in so-and-so, submit that while there is no bar on simultaneous proceeding, disciplinary proceeding and the criminal trial, however, where both the disciplinary proceeding and the criminal trial are based on the same and the similar charges, it is advisable to stay the disciplinary proceeding till the conclusion of the criminal proceeding. Then, my lord, he submits that the writ petition is filed before the challenging the disciplinary proceeding as being contrary to the provisions of law by completing the proceeding under the undue haste, and the authorities ought to have kept in abeyance the disciplinary proceeding during the trial, which is presently pending against so-and-so. So, similar situation, my lord. Here also the inquiry report suggests that there is a chance of causing prejudice, and that's why we have challenged that. And the paragraph 7, Lordship, kindly see. This is the observation by your Lordship.
Yes.
The next returnable, the disciplinary authority in Department of Excise, Government of Assam will not proceed to pass any final order on the inquiry report which is submitted by the inquiry officer. That's all. I'm with the similar prayer.
All right, Mr. Gogoi.
Interim orders are not precedents, my lord. My lord, that is very clear. And that apart, my lord, the order, my learned thing is relying on, my lord, that case has sailed too far, my lord. It's under final adjudication with records. Records have been called for, my lord. And that apart, my lord, has lordship very rightly expressed, my lord, that no final order has been passed till now because he has been given a chance to represent, my lord. Let him represent, my lord. We'll consider if something happens, that's a different fact altogether, my lord. Because what this order sheet at page 71 or 70 doesn't lay down anything, lordship, and the paragraphs relied upon by my lord senior, my lord.
My contention was only on the inquiry, because inquiry has to be conducted independently, not only based on the material of the investigation, man. Here in the material which they have relied, the inquiry officer, absolutely based on the inquiry investigation report, and they have examined only one.
You get your instructions.
My lords.
But don't pass final orders in the matter.
My lords.
Till the next return.
Yes, that will do, man.
Right. But Mr. A. Bora, Senior Counsel, assisted by Mr. J. Patwari, Petitioner, Mr. D. Ugoi, appearing for all the respondents, the Excise Department. Petitioner is aggrieved by the initiation of departmental proceedings against the petitioner purportedly on the basis of the materials, purportedly only on the basis of the materials, materials collected during investigation in connection with what is that, a vigilance case? Is it a vigilance case?
So ACB
PS case.
Anti-Corruption Bureau, man.
What is the
PS
number?
case number 8 of 20. Synopsis document.
Where does one find the number?
In the synopsis number.
In the synopsis itself, my lord.
ACB PS case number 08 of 2021, registered under Section 7A, the Prevention of Corruption Act 1988. So petitioner was also suspended from service on 18/9/2021. So the learned senior counsel submits that the criminal trial is at the stage of evidence, and therefore at this stage, if the proceedings, departmental proceedings, are simultaneously allowed to proceed, the petitioner is likely to suffer great prejudice in the trial, which is presently being conducted against the petitioner. So under such circumstances, petitioner is before the court. It is the submission of the council that although there is no bar for dual proceedings to be initiated, however, the mandate of law and the principles laid down in Captain M. Paul Anthony versus Bharat Gold Mines Limited and other reported in so are required to be followed. And if the authorities proceed to pass final orders on the proceedings, the sub-departmental proceedings initiated, the petitioner is likely to face serious prejudice in the trial which is being conducted against the petitioner. So, considering the submissions made, it is issued return in 4 weeks. Since Mr. Gogoi has entered appearances on behalf of respondents, notices of wait, extra copies be furnished within a period of 1 week from today till the next returnable date. The respondents will not proceed to pass final orders in the departmental proceedings, which is initiated against the writ petitioner by issuance of show cause dated 3rd of January 2023, and in which the inquiry officer has already submitted the inquiry report, and the petitioner has also been asked to submit his representation on the inquiry report, ID communication dated 19th of August 2024. List accordingly after the next returnable date.
Team.
Yes.
Here we have challenged the impugned speaking order dated 7/4/2026, whereby the petitioner's appointment was rejected. Your Lordship may kindly turn to page 66, my lord. Kindly see the grounds, my lord. Views and decisions of SLC. My lord,
where are the grounds?
The state level committee viewed the proposal was not at par with Principle 10 of OM dated 1st June 2015, which provides that if the applications of eligible candidates remain pending and cannot be considered due to want of vacancies for 2 years from the date of making such application will require no further consideration and must be understood to have spanned their force. My lord, here in the instant case, my lord, the petitioner's case was never rejected, my lord. The petitioner's case was, in fact, my lord, recommended by the DLC, page 35, my lord. Again, specific post, my lord. Grade 4 post. Your Lordship may kindly see serial number 7, page 35. Amit Das, my lord. Amit Das, my lord.
What is your ground for challenge?
Ground for challenge here, your Lordship may kindly see the ground for rejection, my lord. There, according to them, the petitioner's case was earlier rejected by the DLC on the ground of non-availability of post, vacant post, but this is not correct. His case was, my lord, duly recommended, page 35, my lord. Amit Das, son of so-and-so, is recommended for the post of grade 4. And secondly, my lord, it was rejected on the ground of lapse of time, my lord. Here, my lord, I have relied on a recent decision, my lord, in case of, my lord, Canara Bank versus Ajit Kumar GK, where, my lord, your Lordship may kindly turn to page 8 of the judgment, my lord. Judicial precedents on the issue of compassionate appointment. Here I have relied on, my lord, para 27, my lord. This is relevant, my lord.
Para 27.
Para 27 at the bottom.
Yes.
Lapse of time could, however, be a major factor for denying compassionate appointment where the claim is lodged belatedly. But in the instant case, claim was not lodged belatedly, it was lodged in time, my lord. The petitioner's father died on 2/6/2012, and the petitioner applied on 11/7/2012, my lord. Here, your lordship may kindly say, I'm reading the last line. If any time limit has been prescribed for making an application and the claimant applies within such period, lapse of time cannot be assigned as a ground for rejection. Here, my lord, lapse of time was, my lord, only it was rejected on the ground of lapse of time. But petitioner applied in time, my lord.
Yes, Mr. Goswami.
25.
Yes.
Mr. Goswami.
Yes, Lordship, here in this case, Lordship, so far, in my knowledge regarding this judgment, Lordship, this judgment is referred for larger bench.
You get your instructions. You get your instructions here.
Lordship.
You get your instructions, we'll take it after 1 week.
Lordship.
Heard MSSP Chaudhary, Learned Counsel Petitioner, Mr. J.K. Goswami, Learned Additional Senior Government Advocate, appearing on behalf of respondent number 1, 2, then 4, 7, 8, and Mr. J. Hendick appears for respondent number 3.
I for respondent number 3, 5, and 9. Lord.
3, 5, and 9. Since the respondents are represented, the learned counsel for the respondents are permitted to obtain their required instructions in the matter in respect of the claims made by the petitioner, that since the petitioner had submitted her claim, his claim for compassionate appointment well within time, the SLC could not have rejected his case on the ground of having submitted a belated claim. What is the ground for rejection? Page number?
Page 66 and 67, my lord.
66.
Firstly, my lord, that it is not at par with
13 years.
and it is not at par with, my lord, principle 10 of OM dated 1/6/2015. That due to lack of vacancy, his case was earlier rejected, but it is not correct, my lord.
And even the Lord, kindly turn to the page 67, Lord.
Yes.
Lordships, before decision, Lordships, last
Yes.
two line. The proposal for the compassionate appointment of Obid Das, but it could not be considered after a lapse of 13 years, as the conditions of the immediacy no longer existent. This is given.
But as per the recent guidelines, it cannot be rejected on the ground when the petitioner, my lord, applied in time, my lord.
The proposal of the petitioner was rejected as the authorities held that it would not be considered after a lapse of 13 years, as the condition of immediacy was no longer existent. So I think we should issue notice here because issue notice return since the respondents are represented notices away. Extra copies we furnished within a period of 1 month. Placed after return.
Team.
It please.
Yes.
It is second time it is under. Petitioner had applied for assistant accounts officer in the FGCL Lordship, where form posters are marked for reserve category candidate. And when result was declared, he found that his marks was 49 in merit list, and therefore he called for RTI. When RTI report was submitted, he found that 9 number questions marks has not been given. On the given, he approached before the honorable court, filing 8 petition, and during the time of filing affidavit counter claim, it has been started that 4 questions are correct by the expert. And regarding 4 questions, Lordship kindly directly go to the page number 97. It's the order of the High Court, Lordship. Below this are para number 6, Lordship. As regard the first four question that is under ID number so and so, the petitioner claims that though his answers were correct, he was given negative mark, resulting in deprivation of marks totaling 4015. This 10 of the respondent as regards the aforesaid 4 numbers of the question is that both the question set by the examiner and answer given in the answer K were wrong, and therefore no marks were given to any candidate. Therefore, Lordship, the finding has been given by the court that page number 98, Lordship, para number 13. Mary?
Yes.
Be that as it may, in the aforesaid backdrop and controversy, this court is of the opinion that ends of justice would be met if the matter is relegated to the appointing authority to verify whether equal standard has been applied to all the candidates, while granting negative marks against those questions, in which case there will be no effect on result or enhancements in case of the marks of any of the candidates, including the petitioner. In the event the equal standard is not applied, the respondent authorities shall have to re-evaluate the marks granted by applying equal standard procedure to all the candidates and accordingly reset the merit list and proceed accordingly based on such determination. The entire exercise be carried out within a period of 6 months from the date of receipt of a certified copy of this order.
Then what
After
happened?
this, yes, Lordship. After this, Lordship, they have page number 100. They have sent a letter to me, Lordship, by disputing 4 questions, wherein Lordship clearly sees in the right side, Lordship, that no equal standards has been applied, Lordship. For 223 candidates in the first question, 0 marks has been given. Lordship, for 100 candidates, 1 marks has been given. Some candidates, including me, minus 2.5 marks has been given in the 4 questions. If correctly these questions has been set out, Lordship, my position will be 59, Lordship, maybe the top list, Lordship, serial number 44. And in the last, Lordship, what they have recorded that from the above analysis, it is seen equal standards has been applied to all candidates while granting marks against this question in the recruiting agency. However, if any further evaluation is required, the concerned resulting agency may be involved as they are fully conversant with the technical parameters and methodologies adopted during the evaluation process. Now, Lordship, it is from this their data, it has been said that no, some candidates marks has been
What
given.
is the option that you applied for?
Lordship, my option is, Lordship, correct, and their option was wrong, Lordship.
No. Page number 100 you come. For
Yes.
each of the 4 questions,
Yes.
they have classified 4 sets of candidates.
Yes.
For some candidates who did not attempt the question,
Yes. Yes.
0 marks.
Yes.
For some candidates with the option ID 11369,
Lordship.
1 mark. Now,
Yes.
it appears that negative marking is there for the other 3 sets.
Lordship.
Now you fall under which set?
I have opted, Lordship, 11369.
11369.
Lordship.
According to you, 1 mark should have been given to you.
Lordship, 1.25 mark, because 1 marks and minus negative has been also curtailed, Lordship. Lordship, if Lordship, so page number 44, kindly take 44 page number. The question, Lordship. Lordship will get the question.
Right. Let them get instruction, Mr. Nath.
Mala, Lordship.
Please get the instruction.
I'm waiting for the respondent number 2, 3, and 4, Mala. Kindly give us some time. I'll obtain instruction in the matter. Mala.
Should we issue notice or?
Lordship may issue notice at this stage.
Right. Mr. D. Monto, learned counsel for the petitioner, and Mr. D. Nath, learned counsel appearing for the APDCL, representing all the respondents.
Mala.
Is it APDCL or GCL?
I am for respondent number 3 and 4.
You are for
respondent 1 and 2
APDCL.
APDCL.
Okay, Mr. Who's your name, Mr. Counsel for APDCL?
B Das, my lord.
B. Das for respondents 1 and 2.
Yes.
And Mr. D. Nath for respondents 3 and 4.
3 and 4.
The respondents being represented, notices of waived, extra copies be furnished within a period of 1 week. Let the respondents complete their instructions and file necessary affidavit if the need so arises. Yes.
of the law.
Lordship, there is an interim order, Lordship, in filing the IA, Lordship, that has been operating. That one post may be kept vacant, Lordship. In page number 70.
You have filed an IA?
No, Lordship, in the earlier petition, Lordship, there is the court has asked to remain one post vacant, Lordship. Because
no, that one post vacant, what?
It's still operating, Lordship. Still operating.
No, how can it be deemed to be operating? It is up to the final order being passed. We'll issue notice on your interim threat.
Lordship,
Consider it after the return. Notice the interim threat to be considered after the return.
Highly unlikely. Lordship.
Item 16.
Yes.
Lordship, here, Lordship, challenging the repetition is the matter inquiry report as well as the order of punishment matter. At this stage, I am praying for notice.
What about appeals?
That has been dismissed by the department matter. After appeal matter, they have passed the interim order at page 73 matter.
Heard counsel for parties issue notice return in 4 weeks. Mr. D. Boy appears for all the respondents. Therefore, this is a waived. Extra copies we furnished within a period of 1 week. Yes.
18.
Hello, sir.
Yes.
The petitioner, my lord, is a father of two mentally challenged children. And my lord, he was transferred from Samaguri Avenue Support to Kampur Avenue Support on 2/8/2025. My lord, he applied for initial transfer, my lord, but that was not considered. After that, my lord, several persons, my lord, which he was my lord, transferred, they were again my lord, retransferred. But my case has not been my lord, considered. There is a distance of more than
That application at page number 23 has been disposed of.
No, 15, madam. Initially, I have applied 15, madam. It's a mutual, madam.
No, page number 23.
23 also, madam. That was not considered.
Huh?
That was not considered.
Not considered.
Madam, initially, I have applied my page 15, madam. There is a mutual.
15.
15. 1/5, madam.
Now, what has happened to the other person?
Other person, he was transferred, madam.
He was transferred.
He transferred, madam. To some other. That is page, madam, 21, madam. That is Ranjit Swigya, madam. Serial number 2, madam. He was transferred, madam, from Samaguri to Soror Revenue Cycle. Initially, when he was transferred from, madam, that is Ranjit.
You want to come from Kampu to Samaguri?
Madam, Samaguri, either Samaguri or madam, Rupuhi, madam. Anyway. Both my children are madam, mentally on the sentence.
Mr. Hendik? Mr. Hendik?
Lordship. It is
There
done by the
appears to
deputy commissioner because my lord, that transfer is made in the within the my lord, that same district, lord.
That same district, I am claiming my same.
So my lord, deputy commissioner, my lord, can do. My lord.
That would be Deputy Commissioner Nogao.
Nogao.
So there is a representation at page 23. We direct them to dispose of. Heard counsel for the parties, the petitioner before this court is agreed by non-consideration of his request for transfer from Kampur Revenue Circle.
So Samaguri, either Samaguri or Rupuhi,
Any other.
So where there is a vacancy, lordship, if there is
within the district of Nogao. Stop the grounds and the reasons ventilated by the petitioner is that of his son and daughter who are stated to be intellectually disabled. Intellectually disabled. Stop. It is submitted that initially he had submitted a joint representation with another employee for mutual transfer, stop which, however, they say representation was not considered, although the person with whom he had requested for mutual transfer was considered for transfer and posting in a different place. So, a different place, while the claim of the petitioner was overlooked. Thereafter, by representation dated 26/9/2025, he had preferred another representation, another prayer for transfer, citing the grounds therein. So, it is submitted that the representation is presently pending before the District Commissioner Revenue in the district of Nogam. So, at this stage, considering the limited prayer made, the court is of the view that the writ petition can be disposed of, the direction to the District Commissioner Nogam to expeditiously consider and dispose of the representation dated 26/9/2025, filed by the petitioner, praying for consideration of this prayer for transfer. So, the said representation will be disposed of within a period of 3 weeks from the date of receipt of a certified copy of this order. So, it is made clear that although the writ petition is disposed of, there is no opinion expressed by the court in the merits of the case. So, writ petition accordingly disposed of. The direction will be carried out by the District Commissioner Nogam as expeditiously as possible within the outer limit of 3 weeks from the date of receipt of a certified copy of this.
Item 19.
Petition challenges rejection of the SLC of my claim for compassionate appointment. But if the petitioner's father died in harness in 2016,
we are issuing notice to the heard Mr. B.P. Bora, Learned Counsel for the petitioner, MSS forward, Learned State Council, enters appearances and accepts notices on behalf of respondent 1 to 6. 1, 2, 3, 4, 5, 6.
No, I am for 3, 4, and
1
5.
and 2. And Mr.
1,
D.
2, and 6, I am appearing.
1, 2, and 6, S. Borwa. 3 and 4. 3, 4, and 5, Mr. D. Gould. Since the respondents are represented, notices are waived. Extra copies be furnished within a period of 1 month. Placed after the return of the writ.
20.
See, as a petitioner who was appointed 2020 and as a chowkidar,
we issue notice for today. What else?
My lord, only one thing. That was 2 points. There is no need such a transfer policy for the grade 4 employees. Issue number 1. That is one ground. And second issue, also kindly see page 24. The authority also we are putting on the question, my lord. My lord, the vigilance cannot pass such kind of order. The matter has to be dealt with by the registered administrative, my lord. And there is no any reflection on what basis, my lord, this transfer order has been issued from one district to another district. Page 24, my lord. It has been issued by the registered vigilance, my lord. Vigilance has dealt with the, my lord, complaint, discipline, posting, other thing, and so forth. The staffs and are concerned, my lord. There has to be dealt with the registered administrative, my lord, normally. And lordship kindly see this order nowhere reflects on what basis, my lord, this order was given effect. Now, lordship, only one thing is that, lordship, so far, civil court rules and order of Gauhati High Court, the chapter 41 ministerial officers contain the condition rule 810, my lord. May I, lordship, play the, my lord, rules?
Yes.
Lordship, kindly see.
So what are you trying to
well, I am trying to project two ground, my lord. First thing is that, my lord, non-ministerial staff cannot be transferred of inter-district, my lord. There is no such transfer policy.
They are what? They are ministerial staff.
Yeah, no, he is non-ministerial.
Non-ministerial.
Malay, he was working as chowkidar. Additional also given the charge of driver. Lordship, page 23.
Additional charge, my lord.
Additional charge. Page 23.
Where is his original? Where is his original appointment order?
Page 19 of your lordship's brief.
Appointment order is 19. He is the chokidar. Afterward, on different stage, my lord, he has given the charge of driver. Last page is, my lord, page 23.
So as a chokidar, is he entitled to be transferred or not?
No, my lord, my reason is that, my lord, since my one person has retired, now in his place, subsequently, my lord, another districts, my lord, one driver has been transferred from there to this district, my lord, then his right will go, my lord. Basically, he's a driver, my lord. Additionally, he is holding the charge. Question is that, my legal 2 points are there. My lord, kindly see just for a moment, rule 810, my lord.
Yes.
The district judge should from time to time consider the question of transferring the ministerial officer of one station to another station in the district whenever they have been in same station or in the same post for more than 5 years continuously. 2. If it is found desirable to transfer ministerial officer from a station but there is no corresponding post of the same grade in any other station within the district, the matter should be reported to High Court so that the transfer to another district may be arranged. 811. After holding the responsible position and dealing with accounts and money for not more than 5 years, a ministerial officer must be transferred to another appointment exam or in the opposite department. Now, Lordship, can I see transfer policy? I have given the copy. Schedule 1.
Yes.
It clearly says transfer is an incidence of service which is usually done in public interest for improving the efficiency of the system. Ordinarily, ministerial staff is not transferred frequently, but for judiciary, the exercise is perhaps necessary to improve the quality of justice delivery system, maintaining discipline, and to remove deficiency of the ministerial staff working to various districts. Quote, keeping above objective in mind, the transfer policy of the ministerial district judiciary or some other than Group B employee is formulated. Clearly, my lord, group other than Group B employee. And my lord, one thing is that also, my lord, that so far the service rule is concerned, their service rule is drafted, service yet to be notified, my lord. Therefore, my lord, there is a full court decision that till notified, the service rule has to be given effect. This is the part of their service rule, my lord. And Lordship, kindly see, so far the authority is concerned. The transfer policy says that, Lordship, just look only last line.
Let the standing council obtain instructions here.
But what he wants in substance is page 19, my lord, he already holds a post. He wants to block another one.
He wants to hold the, he's finding the post of driver to be more comfortable.
More comfortable for him. More.
Yes.
Yes.
All right. You get instructions here.
I will, my lord.
Is there any private respondent? There must be.
Yes, my lord. That private respondent.
Then we'll have to issue notice heard Mr. S. Chamaria, learned counsel to the petitioner, and Ms. S. Sharma, learned standing counsel appearing in the Gauhati High Court. Petitioner is aggrieved by the impugned order of transfer. Where is the order?
Yes, 24.
24. Impugned order of transfer dated 13th of May 2026. Issued in favor of the private respondent, transferring the private respondent from his present place of posting in Bongaigaon to the office of the Chief Judicial Magistrate Gwalpara against a vacant post of driver. So, learned counsel to the petitioner submits that this notification issued is violative of the provisions of the Civil Code rules and orders of the Gauhati High Court. There is also the transfer policy for the ministerial staff in the district judiciary of Assam. So, it is submitted that the transfer order was purportedly issued by the Registrar Vigilance, and the authority issuing the transfer order is not competent, is not the competent authority to issue such orders. So, being agreed, the present petition has been filed.
Stay there, man. My stay prayer is there, man. This operation of this 35
the counsel to the petitioner therefore submits that the impugned order of transfer be interfered with, set aside, and till the writ petition stands disposed of, the order be stayed. MSS Sharma, learned standing counsel, appearing for the respondent number 2, 3, 4, and 5. 2, 3, 4, and 5.
4 is my learned friend.
I am appearing for 1 and 4.
1, 2, 3, and 5.
Yes.
And MSS for Y appears for respondents number 1, 4, 1 and 4. Since the respondents 1 to 5 are represented, notices of which extra copies be furnished within a period of 1 week from today. Steps on respondent number 6 by speed post within 1 week from today. Issue notice on the prayer for interim. List this matter again on 8th of June or 10th of June. 10th of June.
Time being item 1.
Yes, madam.
Yes, Lordship, it is covered.
Maybe disposed. Council for partners. Petition stands disposed of by Central. Disposed.
For orders, item 21.
Your Lordship.
Hmm.
Lordship, in terms of the earlier order, we have taken steps.
Unserved notice returned in respect of respondent number 2. Will you take fresh steps on respondent 2? In view of the office note that unserved notice in respect of respondent 2 has been returned back with the endorsement addressing left, hence RTS was closed. Petitioner is permitted to take fresh steps on respondent 2, the correct address. Matter be listed after the returnable date stop. The office will also make necessary endorsements in respect of the service of notice on respondent part. List after 4 weeks.
22.
Lordship,
Yes,
we
yes.
pay for 4 weeks time to file affidavit in reply.
The opposition has been filed.
Lordship has been filed, but there is some defect. 2 pages has to be eligible, so we have to get it typed. So that rectification will be done today.
Mr. B. Chakraborty, learned CGC, submits that the affidavit will be filed during the course of the day. Within 2 days.
Lordship, affidavit has been filed, but the registry is returned back to rectify defects.
The affidavit has been filed, but certain defects have been raised, which will be cleared within 2 working days. Correct. Counsel for the petitioner is also permitted to file rejoinder affidavit. Release this matter again after 4 weeks.
My lord, I am appearing on behalf of respondent number 15, 17, 18, and 28.
You are Mr.
M. Sharma.
M. Sharma appears for respondent 15, 17, and 18.
18 and 28.
18 and 20. You have filed your counter?
Yes, my lord.
The said respondents have also filed a counter affidavit.
23.
This is your lordship. Lordship, they were required to file affidavits, lordship. As regards to the representation of respondent number 3, lordship, although we have taken steps by way of custody, lordship, they are still not required.
You have taken steps on respondent 3.
Respondent number 3 and 4, lordship.
3 and 4.
And we have accordingly filed our affidavit as well.
And what about the respondents?
Yes, Lordship, Learned Counsel T.C. Sutia is appearing for
This matter, Lordship, through BC, he unable to appear before this court, Lordship. Kindly, whether affidavit filed or not, I have not instructed, Lordship.
Matter be relisted on Wednesday, day after. As it is submitted that the Government Council entrusted with the matter, Mr. T.C. Sutia, who is unable to appear through virtual mode before this court. Release the matter accordingly. Wednesday.
And your best.
Okay.
24.
Yes, Mr. Sharma.
This matter relates to my lord, granting permission to include my lord NEC Shillong and my lord accountant. That particular 5 and 6.
You have filed some IA.
Yes.
IA for?
For granting permission, my lord, to include 2 respondents, NEC Shillong and my lord Principal Accounting General. As
Any objection, Mr. Doctor?
My lord, I have no objection, my lord, but the institute taken over by the Government of India in 2000 or 1999, and they are presently under the Ministry of.
No, they are praying for implement of respondents. Any objection to that?
No, my lord.
All right, heard Mr. E.K. Sharma, learned counsel for the petitioner, Mr. A. Doctor, learned CGC appearing for the respondents. The IA has been filed seeking implement of which respondents?
Northeastern Council, my lord, NEC Shillong, and my lord Principal Accounting General Assam.
NEC Shillong and Principal Accountant General Assam. It is submitted that in the accompanying writ petition being WPC 2951, the claims by the writ petitioners are in respect of. What is your claim in the writ petition?
Inclusion as an old pension scheme.
Is the claim for inclusion under the old pension scheme. Stop. Accordingly, it is submitted that the opposite parties, NEC and Accountant General Assam, would be necessary party, and therefore by this IA, their implement is sought for. The Mr. Doctor does not object to the prayer made. Considering the submissions made, this court is of the view that considering the prayers made in the writ petition, that considering the claims of the writ petitioners in the writ petition, that they are seeking inclusion under the old pension rules. The opposite parties would be necessary respondents in the accompanying writ petition. Accordingly, prayer made is allowed. I therefore stands allowed disposed of. NEC and Accounting General be arrayed as respondent numbers
5 and 6.
5 and 6 in the writ petition being WPC 2951 of 2025. So petitioner will file amended course title within 3 weeks. In the writ petition, you write, in view of the order passed today, so and so are arrayed as party respondents 5 and 6, and amended course title be filed within 3 weeks, and the writ petition be listed thereafter.
Item 25.
Maladin, may I please, Your Lordship?
Yes.
Maladin, item number 25, I am appearing for number 224, 2, 3, and 4. Malad, I pray for 1 week time to file affidavit in opposition in the matter, Malad.
Yes. Any objection from the petitioners? Petitioner, any objection?
No, Your Lordship. Your Lordship, interim relief was granted to us. That may come.
Mr. E. Nath, learned counsel for the petitioner, submits that appearing for respondents number
2, 3, and 4.
2, 3, and 4.
Lordship.
Submits that renews his prayer for filing.
I have received my instructions. Affidavit is ready, Malad. I'll file within a week, Malad.
Submits that instructions are complete. He is
Lordship.
like to file the affidavit within 1 week.
Hello.
Prayer made is not objected to by the counsel to the petitioner, who however submits that the interim order passed earlier be extended. Accordingly, matter will be listed after 3 weeks by which time the respondents will file their affidavit and the petitioners are also given liberty to file their rejoinder affidavit.
Lodge.
If so advised, interim order passed early will continue till the next date of stay.
Lodge. Oblige, Lord.
For admission, item 26.
Yes.
Pandit, there was the order dated 9/3/2026, my lord. Honorable Court, my lord, directs my lordship to receive instruction.
Any instructions?
Yes, Lordship, I have received the instruction. As per my instruction, Lordship, she has received, she have obtained lower marks than the cutoff marks in the OBC category as well as unreserved category, Lordship.
Can you bring it by way of an affidavit so that the petitioner will get an opportunity to rebut?
Okay.
How much time do you require? 10 days?
That may be fixed, my lord. 23 methods.
The counsel for the learner CGC submits that the instructions are complete. She would like to bring it on by way of an affidavit within 10 days. So, Mr. K.R. Patgiri appeals for the rich petitioner. Accordingly, matter stands deferred to be relisted again on 15th. 16th of June.
27.
May I please, Your Lordship?
Yes.
Lordship, earlier, another standing counsel was withdrawn. File was misplaced, my lord. My lord, file is misplaced. So kindly allow me 3 weeks and direct the petitioner to provide a copy, my lord.
File misplaced.
Otherwise, my lord, this fully covered case of
No,
recent
let
judgment, my lord.
let them at least reconstruct the file. Their file is misplaced. Therefore, you should go digital so that you can reconstruct your file without any worry. Mr. H. Das appears for the writ petitioner. M.S.N. Das, standing counsel for the PWD. M.S. Das submits that the brief for the department has been misplaced. Therefore, she seeks some time to reconstruct the brief. A request is also made that the petitioner be directed to serve an extra copy to facilitate reconstruction of the brief. So, Mr. H. Das fairly submits that he will furnish an extra copy of the complete petition within a period of 1 week. Accordingly, matter be listed after 2 weeks.
Date may be
17th. Sorry. 1 minute. It will come after vacation. List on 15th of July.
Items 28 and 29.
I am appearing on behalf of item 29. Here in this case, my lord, item 29 is presently working as an Anganwadi worker or Anganwadi helper and seeking promotion as an Anganwadi worker. And
Have you filed a rejoinder affidavit?
yes, we filed a rejoinder affidavit because the respondent has filed affidavit saying that
but your rejoinder is
we
not
failed to submit certificate.
Your rejoinder is not connected to the case record.
Then, my lord, exactly, rejoinder may be.
Well,
filed on 6/5/2026.
Okay. It is here. Yes.
My lord, they are virtually saying that our certificate is not proper. This is annexed in the writ petition. My lord, as
what is your claim? You want a promotion?
we want promotion. We are presently working as an Anganwadi helper, and we have I have rendered 14 years service as a on-body worker. So as per the guideline, I am entitled to be promoted based on my experience. And we have annexed in the writ petition the experience certificate issued by the CDPO dated 7/10/2024. We have annexed it as Annexure 6. Their affidavit goes to show that our application is not with complete information, and partially they want to say that our certificate is not proper, and therefore, my lord, the petitioner on our advice, my lord, she has approached the CDPO Mankasar on 26/3/2026 and requested to issue a proper experience certificate. We have stated in our resented para 3, my lord. That was not responded, and the CDPO was saying that without the honorable court's order, they cannot issue any certificate. If this honorable court direct, then they will issue. That was
what certificate you want?
My lord, experience certificate. My lord, experience certificate. What we have, my lord, I have annexed in Annexure 6, page 29 of petition, that I have rendered 14 years service under Mankasar ICTS project. But filing their affidavit, they are saying that our application for upgradation is not with proper information. Partially, they are saying that this certificate they are not treating as a proper certificate. Then, my lord, they let them issue a proper certificate, my lord. That was also not considered.
Mr. Goswami, what documents were not? How was the form not complete? What was not there?
Paragraph 4 in my affidavit, Lordship, page 45, Lordship. Running page 45, Lordship. Paragraph 4.
She has failed to submit her certificate.
Yes, an application, petitioner filed an application for Anganwadi worker, but the application submitted by the petitioner is incomplete as per the notification issued by the department with guidelines, Lordship. That is the issue, Lordship.
No.
It is not only the experience certificate, the application which is submitted, it should be as per the notification and notification issued by the department with guidelines.
No, Mr. Goswami. In what way is the application not as per the guidelines? What was the deficiency in the application?
The notification is there, Lordship. The notification itself stated some guidelines, Lordship. It is page 21. It started from page 21, Lordship.
Yes.
Yes. These are the guidelines, Lordship. And the application which is submitted by the petitioner is not followed according with the guidelines, Lordship.
No. Guidelines means which guideline has not been followed?
That is not categorically stated in the affidavit.
That's a very vague. That's a very vague statement to say that it does not satisfy the guideline without indicating which guidelines have not been followed.
Now, again, she has failed to submit her certificate as regards her experience, Lordship.
That she has enclosed at page 29. That this is her certificate. She has enclosed.
Page 29, Lordship.
When was the application submitted, Mr. Sikdar?
My lord, my application is also here, my lord, in the petition, Annexure 8, page 35. My lord, vernacular person at page 37. This was our application. And this is, in fact, my lord, in a standard form. Was submitted on 7/10/2024. Pursuant to advertisement, my lord, Annexure 7. Annexure 7, page 30.
Mr. Goswami, you have to tell us how the guidelines have not been satisfied. What was the shortcoming? Because the affidavit is not clear. It only says that it is not as per the guideline. What has not been followed as per the guideline?
Yes, Lordship, that's why I have to take instruction on that regard, Lordship. Lordship, here
She failed to submit her certificate as regards experience. That is the first objection.
yes, Lordship,
But
yes.
page 29, they say that this is the certificate they submitted. Now, whether this certificate is available in the records along with the form. Heard Mr. A.K. Siddharth, Learned Counsel for the petitioner, Mr. J.K. Goswami, additional senior government advocate appearing for the state. The grievance of the petitioner is that the claim for promotion to Anganwadi worker in which Anganwadi?
Talibwi Kumar Gati, 185.
Page number.
Page, my lord, in the advertisement, my lord, mention a serial number.
Page number.
Page 30, my lord.
This Salibui, 185 number Salibui Kumar Ghati under Dhanua Gaon Panchayat in the village of Salibui. In which district is this?
My lord, it is
South Salmara, Mankacha district. Is that page number 30? So, the respondent number 4 has filed their affidavit where there is an averment that the petitioner has failed to submit her certificates regarding experience. So, the same is refuted by the petitioner by filing their affidavit in reply. Stop. The counsel for the petitioner has also drawn the attention of the court, page number 29, to submit that the certificate of experience was issued on 7th of October 2024 by the CDPO Mankachar ICTS project, Mankachar South Salmara, Mankachar district. And this is the certificate which was enclosed. So, be it as it may, the counsel for the petitioner further submits that the petitioner has approached the CDPO Mankachar again on 26/3/2026, requesting for issuance of a proper experience certificate in format. But the petitioner appears to have been informed by the CDPO that no such certificate can be issued unless orders are passed by the court. So, better. Under such circumstances, Mr. Goswami will obtain instructions, specific instructions as to the experience certificate stated to have been enclosed by the petitioner in the form submitted. If required, the relevant reports be produced before the court for perusal. Release this matter again on.
Lordship.
Yes.
Lordship, I will bring the instruction, Lordship, as per the direction of this honorable report. But kindly see Annexure 8, Lordship. It is the original application filed by the petitioner, Lordship, 37, Lordship. Herein, it is categorically stated in 10, 11, 12, and 10, 11, 12, wherein the age certificate is, we stated that incomplete application submitted by the petitioner is incomplete because, Lordship, she has not submitted the age certificate along with the application.
That is not there. Is it not? It's not mentioned in your affidavit.
No, it is not mentioned in the affidavit, but from Annexure 37, it is clear.
No, you get the instructions.
Yes, Lordship. I will bring on the reports. Yes.
Can you get it on 17th?
17, Lordship.
19th June.
19, Lordship. I will.
And in item number 28, my lord,
Ah,
both are analogous, my lord. Here, my lord, the petitioner is participated in the selection process, my lord. And thereafter, selection process was completed and a person was selected and his name was forwarded to the director office that was pending. And today itself, my lord, respondent number 4 filed an affidavit, my lord. And the affidavit also speak the same matter. So here, madam, basically, I oppose the promotion of the petitioner of respondent number 29 because there is parallelly a selection process was proceeded for filling up the vacant post, and that has already been completed. And so far, I heard from the submission of my senior colleague, my lord, the petitioner of 29 has submitted his application for promotion on 7/10/2024, whereas the for filling up the vacant post, my lord, advertisement has been published on 1/10/2024.
29.
It's 28, my lord.
Huh? 28.
28.
Yes. Is there a private respondent?
No, because I could not know about his case before I filing this writ petition. Later on, I could learn those matter was taken up, my lord.
Any affidavit filed here?
The respondent number 4 has filed today, my lord.
Oh.
But it is in
That is not
record
in
or
tag,
not, I
lordship.
don't know, my
Yes. It is not come.
Today I was served.
Yes.
Right. The respondent 4 has filed, is submitted. The respondent has filed an affidavit, which, however, is not connected to the case record. Accordingly, registry to press out the affidavit stated to be filed by respondent 4 and release this matter again on 19th, along with item number 29. The petitioner is also permitted to file rejoinder if so advised in the meantime.
Item 30.
No affidavit filed.
Lordship, this is NCL certificate, OBC NCL certificate. Already similar in similar letter, Honorable Court passed order, Lordship. As per
He falls within the 6-month period.
no, Lordship, that is as per the notification 2017 of SSC notification within after 5 months, 9th May 2025, Lordship.
Lordship, this matter is a little bit different, Lordship, about that on those matters, Lordship. Lordship, he had the certificate on the date of the last date, on the last cut-off date. I have annexed that, Lordship. That is that's why, Lordship, the Honorable Court filed order dated 6/2/2026. Query was made at paragraph 4. Lordship may peruse the paragraph 4 of 6/2/26. Order dated 6/2/26.
No, if the cutoff date is 5/9, cutoff date is 5/9, isn't it?
No, as per the advertisement, cut-off date was 14/10/2024. 14/10.
14/10 is the cutoff date.
Yes, cut-off date. And I had the certificate of 14/10 at Annexus C, page 51.
Was it produced?
But, Lordship, Annexus C, page 51.
That is not NCL.
Annexure?
C, page 51.
Ah.
Lordship may see the date, and there is a note also below in handwritten part.
This is not NCL certificate, Lordship.
This is not NCL.
But, Lordship, for that, Lordship may peruse the advertisement at page 34. Page 34, clause 12.6.1.6.
Hmm.
12.6.1,
Yes.
it says at the time of DME, the documents verification, the following documents will be verified. Then Lordship may come to 12.6.1.6 below.
Yes.
It
Caste
says,
certificate.
yes, caste certificates as applicable in the format prescribed. Lordship may note the word format prescribed in Annexure 6, Annexure 7. So Annexure 7 I have, it is at page number 48A. Page number 48A is the format enclosed along with the Lordship, the advertisement.
But where is the requirement of this is creamy layer? You're referring
Yes,
to creamy layer.
6.5 and 6.6.
Yes.
That is, it is mentioned that creamy layer certificate is required, and this
No.
format also.
No. 12.6.1.5.
1.6.
1.6.
Yes. It should be in the format, specific format.
Ah.
And I had page 51 in specific
Where
format.
is Annexure 6? Annexure 6?
Annexure 7.
No, Annexure 6. Where is that?
Annexure 6 Lordship, I have not enclosed that because the Annexure 7 is relevant for me. So I have mentioned in the relevant portion.
Annexure 7.
Yes. And the
Annexure
NCL
7 is a produced.
Yes.
It is by OBC certificate.
Yes. I'm OBC. I'm claiming OBC.
But you will have to give the NCL certificate.
Yes,
also.
NCL certificate is there at page number 55.
This was issued on which date?
And this covers the 6 months. That's it. 25/4/2020.
So cutoff date would be from
Date 14/10.
14/10/24.
Up to, yes, Lordship, it is within the limit, Lordship, in the cutoff. As per the notification, he is eligible, Lordship.
So we dispose that off. Is there any other objection to that?
But another annexure, page 50, annexure B1. This is not within the limit, Lordship.
No, therefore, subsequently, this was obtained. That was 55 is subsequent. That was of 23.
At the time of his document verification, he submitted this annexure B1, Lordship. After that, this annexure E was submitted.
I had submitted that. I had submitted both, all notes.
No, in the face of if supposing annexure E is submitted, if annexure E is submitted,
He is eligible.
E was submitted when?
At the time of document verification on, let's say it was 4/12/2025. Next page, page 56.
Why was B1 submitted?
That's it. No, B1, that B1 was not submitted. I have annexed it to clarify before the Honorable Court. That initially that earlier passed many orders. It's within the 6 months.
So only page 55 was submitted.
55 and I had submitted that also. 51 was also submitted. Both I had submitted.
Why did you submit both?
51 and 55 because on that date the 55 documents and a certificate was not with me on 14/10.
And during verification, which was there?
Then verification, both, I have submitted both on that one, 55 page, 55 words. 25.
So 55 is within the cutoff limit.
Yes.
So therefore, the benefit has to be given to him.
Yes.
All right, but counsel for parties. Do you have a copy of that order?
55526. It's in 5 of 26.
5 of 26. Order side. Okay, heard counsel disposed.
Obliged.
Obliged.
31,
Affidavit will be filed during the course of the deadlock sale.
MS Purwa, Learned CGC submits that the affidavit on behalf of the respondents will be filed during the course of the day. Mr. K.R. Patgiri, Learned Counsel, petition appears for the petitioner. Seeks liberty to file rejoinder if so advised. Release this matter again in July. 17 July.
Obliged. But interim order matlab pass ho.
Interim order, if any, passed early will continue.
Obliged.
32,
Yes.
Yes, Lordship. Last occasion, Honorable Court directed to bring an instruction, Lordship. As per our instruction, the petitioner may go for surgery, Lordship, within 2 months, and after that, let her to posted go for that newly transferred post, transferred place, Lordship. Within 2 months, he may go for surgery.
So who is to undergo the surgery?
The petitioner number 2, wife, your lordship.
Wife.
Your lordship may kindly peruse the order dated 25/5/2026.
Yes. So they have come up with the instruction that they can accommodate you for 2 months.
Lordship.
After that, say have to be joined in newly.
Till surgery.
Yes, Lordship.
Till the surgery is
Within 2 months,
undertaken.
surgery will be go for surgery.
2 months or 3 months?
2 months, Lordship.
2 months.
Yes.
From today.
From today.
Yes, Mr. Botago.
Lordship. That will do, your lordship.
All right.
Till her surgery.
Third, Mr. S. Botago, Learned Senior Counsel, assisted by Mr. S. Day, for the petitioner. NMSS Murwa, Learned CDC, for the respondents. The
On behalf
petitioner
of Arkadev Choudhury.
is on behalf of Arkadev Choudhury, Learned CDC on behalf of Arkadev Choudhury. The petitioners are husband and wife and are serving as constable GD under the CRPF Gauhati. They are currently posted at Group Center Gauhati. Petitioner number 2 suffered some medical ailments and requires regular medical treatment, including a surgical procedure. So, considering the submissions made, the Learned CGC, by the last order dated 25/5/26, the Learned CGC, Learned DSGI was permitted to obtain instructions as to whether the petitioners can be accommodated within a certain unit till to facilitate the surgical procedure stated to be required to be undergone by the petitioner number 2 and the time period for which they can be accommodated. Stop there. Today, MSS Barwa, Learned CGC, appearing on behalf of the Learned DSGI, submits on instructions that the petitioners can be accommodated in Gauhati Group Center for a further period of 2 months from today till the petitioner number 2, within which the petitioner number 2 will be required to undergo the surgical procedure if so advised medically, And thereafter, they will have to proceed for their respective posts on transfer. So, this submission of the learned CGC is accepted by the council petition, and accordingly, the writ petition stands closed. And accordingly, in view of the submissions recorded on behalf of the learned DSGI, the writ petition stands closed. So the petitioners, the respondents are directed to accommodate petitioners for a further period of 2 months, further period of 60 days. A further period of 2 months, 2 months from today, and within which the petitioner number 2 may undergo the surgical procedure if so advised medically. Stop. After the expiry of the period of 2 months, the petitioners will resume their posting. Will proceed for their respective places of posting. They are posted in 2 different places.
2 different places now.
Respective places of posting. This is that overnight.
That's overnight, your lords.
Overnight.
They say, your lordship, from Jalandhar to
Overnight journey.
Overnight. Deeply obliged.
Yes, post.
33.
There.
Lordship, here I want a week time, Lordship. Let it be on 9, Lordship. I will get the instruction, Lord, by 9.
9.
9, Lord.
Why 9? Let it be on 10.
Lord.
10.
Lordship, Lord. Lord.
On the request made by the council for the irrigation department, Mr. N. by the matter stands deferred. It is tabled.
On 10th, my Lord.
June, 10th of June, Mr. Reyes Portabu for the petition.
Obliged.
34.
My order is 2nd of February, my lord. These honorable directed PWD and Accountant General to file affidavits, my lord, in view of the developments in the case. PWD has filed, my lord, but AG, I think they have got some instruction, my lord.
Affidavits filed.
Filed by PWD, my lord.
PWD. Who is required to file now?
Accountant General, my lord.
Yes, Accountant General.
One order, I have received instruction. Anyhow, this is I'll bring on record to 3 days time may begin. 1 week may be given.
Mr. C. Barwal and Standing Council, Accountant General, submits that the instructions have been received. He would like to file the affidavit within 1 week. Prayer made is allowed. List is better after 1 week. Stop. The PWD department has also filed their affidavit in the meantime. Has also filed their affidavit. List after 1 week.
35.
Obliged.
Lordship, in this matter, Finance Department is yet to file their affidavit. Since the past 2 years, they have been taking time to file affidavit, Lordship.
Lordship, in this matter, we have received instruction, Lordship. We are filing.
Lordship, last occasion may be given, Lordship. Since 2 years, several occasions they have taken time.
Mr. P. Nayak, additional AG appearing for the filing, submits that instructions have been received. He would like to file the affidavit within 2 weeks.
Short date maybe.
Release this matter immediately after reopening of the ensuing vacations, and the week beginning from 20 July. The petitioners are also permitted to file their rejoinder if so advised in the meantime. Mr. A. Fupan appears for the GAD department.
I have filed my affidavit.
And submits that they have filed their affidavit.
Lordship, as last occasion, Lordship.
Yes, you file it.
36.
My please, Lordship. This matter was sent to mediation. It is successful.
Mr. Chutia, you have muted yourself. We can't hear you. You have to unmute. We can't hear you. We still can't hear you. You have to unmute yourself. Anyway, it's gone. Is resolved through mediation.
Yes, Lordship.
Where is the mediation report?
Report is submitted. It was dated 25/3/2026.
Any agreement worked out?
Yes, Lordship. 50/50. They will share 50/50 of the pension.
No. Is there any agreement signed?
No separate agreement.
What is there in the report only?
Last part.
The
Last
heard
paragraph.
counsel for the parties, the matter was referred to mediation. The mediator has submitted the report dated 25/3/2026. As per the mediation report, the parties to the writ petition, being petitioner number 1 and the private respondent number 8, have resolved the dispute between them. So they have agreed to share, and they have agreed to accept the pension of their late husband, namely late Sahabuddin Mazumdar, and apportion it as 50/50 between them. Who's for the first wife? Petitioner. Who's for the petitioner?
Petitioner, I am.
So you will have to receive and give 50% to the respondent 8.
Yes.
Accordingly, the writ petition stands disposed of in terms of the settlement arrived at by and between the petitioner and respondent number 8. Stop. As per the agreement and settlement arrived at before the mediator, the petitioner, on receipt of the pension, family pension of late Sahabuddin Mazumdar, will apportion 50% thereof to the private respondent number 8. Do you have a bank account? Respondent 8?
Yes, Your Lord.
Can you give the particulars? It is available in the mediation report.
No, Your Lord, it's not available.
In the bank account as reflected in the mediation report, SBI account number so and so, SBI, Sonai branch, Silchar, IFSC number so and so. Stop.
Earlier, Lordship, it was sanctioned to her, respondent number 8.
Yes.
By the department, it was sanctioned to the respondent number 8.
In the service report, respondent number 8 name was present.
All right, then you write, petitioners have agreed to apportion the pension amount so and so, and ordinarily the petitioner who claims to be the first wife was required to be released the amount, was required to receive the amount of pension and thereafter apportion the same. Stop. However, in view of the submissions made by the counsel for the petitioner and the respondent 8, that since the name of the respondent 8 was reflected as a nominee, the pension, family pension, has been released to the respondent number 8. Stop. If that be so, the respondent 8, upon receipt of the family pension in favor of late Sahabuddin Mazumdar, will forthwith apportion 50% thereof and transmit it to the petitioner in the bank account reflected in the mediation report, namely so and so, so and so, so. For the record, the mediation report is also extracted below, along with the bank accounts. writ petition accordingly stands closed in terms of the mediation settlement arrived at by and between the parties. Mr. T.C. Sutia, additional senior government advocate, represents the respondent number
6, Lordship.
respondent number 1.
5 and 6.
1,
5 and 6.
1, 5 and 6.
I'm for 2.
MS S. Borwa, you are appearing for?
No, Lordship, TC Sutia appearing for 1, 5 and 6, Lordship.
Mr. J. Hendik appears for respondent number 2. And Mr. C. Borwa for respondent number 4. Disposed. Who is for respondent 8?
Yes, Your Lordship, Mr. M. Rajbarbia, sir. I
M.
am on
Raj-
behalf of Mr. M. Rajbarbia.
M.
M. H. Rajbarbia.
M.H. Rajbarbia appears for respondent 8. Yes, disposed.
Plus. 37.
May it please your lordship.
Yes.
In this writ petition, the petitioner is challenging his removal order pursuant to a disciplinary proceeding method. The humble contention of the writ petitioner, the charges were vague. The inquiry officer did not consider the statement of the eyewitness which was present at the place of occurrence, and there are various other discrepancies like that.
Where is the inquiry report?
Yes, Lordship will find the inquiry report at page 46. PW1 was the eyewitness.
What is the punishment issued?
Removal from servicemen.
What about the appeal?
Appeal I have filed, my lord. It is pending since 23/8/2023.
Why the appeal is pending, Mr. Goswami?
Lordship,
Why is
Penalty
the
order.
appeal pending?
Penalty order was passed on 17/7/2023, page 64, and appeal was filed on 23/8/2023, page 66.
So we'll pass an order directing the appellate authority to
yes, Lordship.
pass a detailed order taking into account the inquiry report and the findings of the disciplinary authority.
Those grounds have already been taken, my lord, but since the charges itself are not specific weight, my lord, I'll have to again come back, my lord.
Where is your appeal?
At page 66 it starts from, page 66, annexure 9 to the writ petition.
We have taken all these grounds before the appellate authority.
Yes, but they're sitting over the matter, my lord, and
So therefore, all the
my
more
lord,
reason why they should be directed to dispose it off. What is it? Why should there be two forums? Why should the matter be pending before two forums?
it's true, my lord, but
It is
when-
possible that the appellate authority may not agree with the punishment imposed.
Absolutely true, my lord, but since 2023 they have done nothing, my lord, and we are in 2026, almost half year gone. That should kindly adjudicate, my lord, otherwise, my lord, for last 2.5 years they have done nothing.
Court
my
may
lord.
fix a time for this.
So it's
Then,
better, my lord, because- and on your lordship.
the pleadings are complete in the matter. Issue rule, call for the records. Matter be listed for
Received,
hearing. The
Records are
Received,
here,
received.
Records are
Records
there.
is received, yes.
matter be listed for hearing in the month of July. The part 2 hearing list.
Deeply observed.
38.
May I please, Lordship, in this matter, Lordship, directed to bring the circle officer's report on record, Lordship, Assistant Commissioner Tamulpur, and kindly allow me to 1 week time to bring this, Lordship.
On the last date, Lordship, they were granted 1 week opportunity. Otherwise,
Yes, the last chance, as a last chance, Lordship, and we grant once.
kindly see the order dated 18/5/2026.
No, we had already ordered that if you don't file, then consequential
Yes,
orders
Lordship,
will follow.
with
Why was it not filed?
kindly grant, Lordship, 1 week time. Within 1 week, I will file, Lordship.
Despite the order dated 18/5/2026, the Deputy Commissioner Tamulpur having been permitted 1 week's time to file the affidavit, the same has not been filed. But up to date, the government advocate renews a prayer for further time. So, it is submitted that the affidavit will be filed within 1 week.
Yes, Lordship, 1 week.
Will be filed within 1 week.
Otherwise, this report is bring by the on record, Lordship. Private respondent also file the same report, Lordship.
So, do you want to file
Yes,
the
Lordship.
affidavit or
Yes,
you
Lordship.
don't want to file the affidavit? What is
Yes,
what is the report here? What is the report? Where is the affidavit?
Affidavit of private respondent.
My affidavit, the private respondent 7, the Lordship, can you peruse page number 67? There is a paragraph 10 that
Respondent number 6.
Respondent number 6, your Lordship.
Yes, okay. Then
The petitioner,
67.
yes, the petitioner was no longer the resident of survey 448 number Khairabari as she had been married and was the resident of survey number 266 Sahib Topa. Her claim automatically failed because prior to her marriage, she was.
No, where is that report? Where is that report that you have got? Where is the report?
Report
is with them. The respondent number.
So, but you said it is enclosed to the affidavit.
No, not with my affidavit. The DC has submitted a different report.
As per our report, Lordship, petitioner after marriage, became the resident of Sahib Topa Anganwadi Center. Lordship.
The affidavit by the Deputy Commissioner is necessary because according to the government council, the report, the inquiry conducted by the department reflects that the petitioner is no longer a resident of the concerned area where her employment is sought for. Stop. This is also reflected in the affidavit filed by the private respondent number 6. Stop. Accordingly, the said report regarding the residency of the petitioner vis-a-vis the private respondent number 6 is necessary, and therefore what had granted time earlier. Stop. However, the same has not been filed. That the affidavit, the prayer of the petitioner, the respondent, be granted. Affidavit be filed within 2 weeks, subject to payment of cost of ₹2,000 to be deposited before the High Court Legal Services Authority.
Without failing, I will file affidavit within 2 weeks.
They are subject to payment of cost. You have to pay cost for the delay.
Kindly grant 1 week, Lordship, within.
No, 1 week.
Chance,
So
last chance, as last chance, Lordship.
If it is 1 week, then you have to pay 4,000.
Kindly grant last chance, Lordship.
All right. As a matter of last chance, matter stands deferred to be listed after 1 week, by which time the State Council will endeavor to file the affidavit. containing the report as directed. Stop. Post proceeding. List according.
Date may be fixed.
1 week. It will come on 10th of June. 10th of June.
39.
Pleadings are complete.
Pleadings are complete.
Pleadings are complete.
The matter the
This is a departmental proceeding.
But this
Pleading
matter
with
will have to be heard at some length.
Yes, pleadings are complete. Issue due, all for the records. Matter be listed in the partial hearing list in the month of July.
That might be fixed, my lord.
Criminal को मात्र नहीं. Recognition.
Item 42.
My
42.
My lord, I am for the petitioner, my lord.
Yes.
Lordship, my senior Mr. H. Gupta is in legs in another court. Lordship, the matter will be taken up to some time.
My lord, on the last occasion, my lord was pleased to direct me to file a supplementary disclosing the general conditions, my lord. I have filed it to supplementary, my lord.
You have filed it?
Yes, my lord.
No, but the office report says no affidavit filed.
My lord,
please note. Who is your local counsel here? You verify, and we will keep the matter again on 9th of June.
My lord, 9 June.
Yes.
9 June, my lord. Yes, my lord. 9 June.
9 June.
Am I audible, my lord?
Yes, you are audible. Counsel for the petitioner submits that the supplementary affidavit was filed in deference to the earlier court's order. Stop. However, the office note dated so and so reflects that no affidavit has been filed. So, office to verify as to whether the additional affidavit has been filed. And if so, then connect the same to the case reports.
Well,
matter on 9th of June?
9th of June, my lord.
Yes. MS
But it was filed on 29th of May, my lord.
Right. The counsel for the petitioner submits the supplementary affidavit was filed on 29th of May. MS so-and-so appears on behalf of Mr. H. GC. List on 9th.
May I be allowed to appear virtually, my lord?
Yes, you don't need permission. All counsels are permitted to appear virtually if you want.
Much obliged, my lord. Much obliged. May I take your leave?
Yes.
43.
I know the matter pertains to disciplinary proceeding, my lord. Record may be required, madam. It has been listed for
Pleadings are complete.
Pleadings, we have filed our affidavit in opposition on 6th of January 26.
Would you like to file a rejoinder?
I will.
Counsel for the petitioner is permitted to file rejoinder affidavit. The affidavit in opposition filed by the respondents. Parade is made to have the matter relisted after 3 weeks. Relist this matter again after 3 weeks.
Kindly give the dates.
Huh?
You'll also kindly fix a date.
23rd June.
Released on 15th of July.
My lord, can it be on 18th of July, madam?
Huh?
Oh, July, okay, madam. 15th July.
Yes, 15th of July.
44.
My lord, in this case, my lord, two issues were raised, my lord. One, non-release of a provisional pension, my lord. That has been released as recorded in the last occasion. Second point, my lord, regarding arrears, it is our specific instruction, my lord, that those arrears, my lord, of the petitioner pertain to while he was serving in Hamring division, my lord, under the DFO Hamring. And my lord, DFO Hamring reports to my lord Karbi Anglong Autonomous Council, my lord. So, my lord, on the last occasion, my lord, I had suggested that the petitioner may, my lord, make Autonomous Council a party, my lord, because the arrears will come from their order, my lord.
Autonomous would be NC Hills.
Autonomous
Karbi
Karbi
Anglong.
Anglong Autonomous Council. Yes.
Yes, Mr. Counsel.
Last option respondent prayed for time to file affidavit in opposition, but it has not been filed yet.
This is our instruction, my lord.
Lordship kindly pursue order dated 8/5/2026.
A provisional pension has been released.
Release, my lord.
Third counsel for parties, Mr. Rai Botaku, Standing Counsel Forest, submits that the provisional pension has been released to the petitioner. So, however, his claim for arrear salary pertains to the period when he rendered services under the Karbi Anglong Autonomous Council. Stop. Therefore, it is the Karbi Anglong Autonomous Council who is to be directed to examine the claims of the petitioner regarding his arrear salary. And stop. He, however, submits that the Karbi Anglong Autonomous Council is not arrayed as a party. Stop. Petitioner seeks liberty to complete his instructions, and if so advised, implead the Karbi Anglong Autonomous Council by taking appropriate steps. Release this matter again in the month of July on a date to be fixed by the registry.
Apply.
45.
Made legal.
Yes.
So, this is a repetition wherein the petitioner's candidature was sought to be cancelled by the All India authorities. But what happened in this matter, the petitioner was a railway employee, my lord. Then he applied through proper channel for grade 7 post in oil. He participated in the selection process and he was selected. But the railway authorities, they did not give the NOC or did not release the petitioner. Consequently, my lord, the Oil India authorities wanted to cancel my candidature. Against that, my lord, I have approached this honorable court, and this honorable court protected my candidature. Now, in the meantime, my lord, the railway authorities rejected my application for grant of technical resignation. That was challenged before the learned tribunal, and learned tribunal allowed the OA. Against that OA order, my lord, the railway authorities approached the High Court. High Court, my lord, upheld the order of the tribunal. Division bench of the High Court upheld the order of the tribunal and directed the railway authorities to release me. According, they have released me from railway service, my lord. Now, only thing left is that I have already submitted application before the All India Limited authorities, incorporating all the development and allowing me to join the respective post, because still the post is lying vacant, my lord, pursuant to interim order passed by this honorable court. Now, additional affidavit I have filed incorporating all these subsequent developments, my lord. So now the thing is left. My brother has to take a call with regard to my lord, giving my appointment, or else, my lord, if they object, my lord, then your lordship has to decide. Lordship, person to receive of the additional affidavit I have forwarded to the same to the Oil India Limited, lordship. Just now we have received certain instruction, lordship, through email, lordship. So lordship may grant us 10 days time so that we furnish that instruction by way of affidavit.
Mr. H. Das, Senior Counsel, assisted by
May just make one small prayer.
Mr. K. Polita, and Standing Counsel Oil.
K. Das is appearing for the Union of India, lordship. Rupert Das is studying other court, lordship. He is from
K. Polita, and who is appearing for Union?
Drupad Das. DK.
Huh?
DJ Das, my lord.
DJ Das. Appears for the Union of India. Mr. Purita submits that since the railway authorities, the rejection of the NOC by the petitioner has already been allowed by the CAT Gauhati.
Yes, my lord.
And which order was upheld in a writ petition filed by the railway authorities by the division bench of this court. But he would like to complete his instructions with regard to the steps required to be taken by the Oil India in respect of the petitioner's employment sought under the Oil India Limited. He prays for 10 days' time. Release this matter again on.
So I want to file affidavit, Lordship, because the oil stain is that it is
You
not
want to file an affidavit?
because my instruction desk, we have received the instruction that the petitioner's request for fresh document verification and consequential processing of candidature cannot be considered in light of justification that has been submitted by that email.
The standing counsel submits that you would like to file an affidavit in this regard.
Lord, may I just make one small prayer? One fact I'll just like to place before your lordships. He was already released from railway service on 8/5/2026, my lord. And as of now, he doesn't have any job, my lord. So I requested my brother if he can get the instructions by 8 next Monday. Then it would have been the
Lordship will fix the matter on Friday, next Friday, Lordship. In the meantime,
Next Friday would be 5th or 12th.
Next Friday.
Next Friday is 5th. So I requested for 8 to my learned brother, my lord. If he can push some effort, my lord, and because of the fact that he is jobless right now.
Yes, Mr. Kurita? Is it not a 2026 calendar before you?
Yes. Or Lordship may fix the matter 15th, Lordship.
15th.
But I think my learned brother failed to appreciate my predicament.
Then Lordship may fix the...
Let it be 12th.
12th.
Much obliged.
Yes, 12th. There's agreed to by the council for the parties based on 12th.
The interim order may continue.
Interim orders passed earlier, if any, will continue.
47.
So here, the petitioner is claiming pensionary benefit. Is the son of
who is filed the affidavit? Who is the first wife?
First wife is respondent number 7.
7.
7.
You are the second wife.
Second wife.
So what is your claim?
My claim is on behalf of my son, Lordship. He is claiming pensionary benefit.
What is the stand of the first wife?
They have filed an affidavit. They are denying.
This issue is already settled by the full bench. What further decision is required?
Hello.
Yes.
First wife is living, still living. The second wife, the marriage of second wife is become void because they are Hindu.
What about the son? What about the son?
My lord, son is he is claiming that he is disabled, but till that he has not filed any certificate, disability certificate. He has applied for disability certificate. In paragraph 2, he has mentioned, I have already applied for disability certificate, but the same was not.
Who's for the other respondents?
Lordship, I'm for Accountant General, Lordship. As per Rule 143, Roman 3, Lordship. First, Lordship, pension awarded under this rule sanction will be payable to more than one member of an officer at the same time. It will be first admissible to the widow of the widower. In this case, Lordship, respondent number 7 is the first wife, Lordship. So first she is entitled, Lordship.
Then what about the children of the second marriage?
Lordship entitled, but first first wife will entitle, and then Lordship they will share, Lordship. They can share. But pension will be in the name of first wife only, Lordship.
So you counsel for petitioner, you file necessary documents to show that number one, he is the son of the second wife, born out of the marriage of the husband, and that he is disabled as you claim to be. Bring materials on record.
Then I have to find a rejoinder, Lordship.
Yes, counsel for the petitioner is permitted to file necessary affidavit to bring on record the necessary materials to show that in support of his claim that the child born out of the marriage between the writ petitioner and late Ajoy Chandra Rava is a person who is disabled, is a person with disability. Let this affidavit be placed before the court within 3 weeks. Matter be relisted thereafter. Mr. R.K. Talukdar for Accountant General, and
Yes,
who's
sir.
for the private respondent?
I'm for 7, respondent number 7.
Your
Private
name?
respondent number 7.
Right. And Mr. So-and-so
MP,
for
sir.
respondent 7. What matter है complete कर लेगा. Yes.
Lordship, if a date may be fixed.
No, you first file it, then you make a mention, we fix a date.
Obliged.
Item 49.
In this case, my lord, there was an IA, my lord, that was disposed of, my lord. Pursuant to that, my lord, we would now like to file our affidavit, my lord, in the main case, my lord.
I was disposed of.
Yes, my lord. I first, my lord, striking of my learned senior, my lord, was representing the French agency, where, my lord, they were seeking striking of, but that has been, my lord, disposed
My lord, the respondent number 4 was implemented as per order of this honorable court in IA, and this implement order was challenged by another IA by my respondent number 4.
No, but in the IA 2240, there is no order passed. IA 2240 is seeking deletion of the name.
Please, Your Lordship, may I just submit? In
Yes.
IA 2871, there was another IA application, 2871, wherein we have prayed to recall the order by which we have been implemented as a party respondent. And in that case, the case was disposed of on a finding that I should have gone for an appeal instead of recalling the order. So therefore, Your Lordship, I've communicated with the clients, Your Lordship. Your Lordship will kindly grant me some time, because the party is based at France, Your Lordship.
My lord, 2240 maybe, my lord, disposed of in the light of the order passed on 2871.
No, Your Lordship, no
It is
orders
already
can be passed on that.
Infractors, my lord, 2240 infractors on the light of the order passed in 2871.
Or cancellation of the order which was disposed of, rejecting your application.
Yes.
Similar prayer is made in this IA only.
Yes, ma'am. So it is infractors, my lord. Already in the subsequent IA it is disposed of. Rejected is prayer.
So you withdraw it, we dismiss it, not pressed.
Your Lordship, we have communicated with the client as regards filing of an appeal. Suppose tomorrow in an appeal, the Honorable Court directs that you go and pursue the IA which is pending before it. So that might again come back to square one. So the Lordship will grant us some time, 2 weeks.
My lord, the appeal will be against 2871. Well. appeal, if there is any appeal, it will be against 2871 order, my lord, not 2240.
All right, in terms of the prayer made by the council for the what respondent number?
I appear for respondent 1, 2.
No, Mr. Sinha appears for which respondent?
4.
Respondent number 4.
I am for respondent number 4, Your Lordship.
Respondent 4 in WPC number 3573/2024. And the applicant in IA number 2240/2025. On the ground that instructions are sought for. Instructions sought for are awaited. Matter stands deferred to be listed after 4 weeks. Mr. I. Thakur appears for the forest and
Forest department.
Forest. Mr. Kadir appears for the writ petitioner. Release this matter again after 4 weeks.
The date may be fixed.
Deeply obliged, Your Lordship.
4 weeks, get a date.